Hello, everyone. This is John Sloan with Keller Williams Luxury Homes, and I am pleased to have an attorney on our interview today. His name is Jesse Prather, and we're going to be talking about the importance of having a trust, and we're going to go into some detail on it. And Jesse has done a number of trusts, and we had a conversation the other day with respect to my situation with my mom, who just sold her house. And even though the house was in a trust, she didn't have a checking account that was in a trust. So we had an interesting conversation. I said, hey, you know what? This is really important for people to understand. And if you're not in a trust, we know that you're going to run into some issues with the state. So, Jesse, welcome. And let's get going and talk about the importance of having a trust.
Yes, thank you, John. Thanks for having me, and good morning to everyone. The main importance of a trust is to skip probate. As of April 1st, 2022, the California Probate Code has been updated to increase the gross value of a deceased person's property from $166,250 to $184,500. And what this basically means is that those passing with less than $184,500 in assets in their name will typically not have to do a full probate. So if you have less than $184,000, you don't necessarily have to go through the full probate. They have a smaller version of the probate, which is more streamlined for small estates. But the reason why we're talking today is to skip that entirely. I suggest that people form what's called a living trust. And generally those packages include the living trust. They include what's called a pour over will, meaning if you forget to put an asset in the name of the trust, when you pass through your pour over will, it pours over into your trust. So with living trust, it's the pour over will. And there's also what's called an advanced healthcare directive, which, let's say you were in a car accident, it would list who can make your medical decisions for you, on your behalf in the hospital. And the fourth and final document would be what's called a statutory power of attorney, which again, if you're in a car accident and you're in a coma and you can't deal with your banking and or your real estate, your power of attorney will list an agent for you, who can deal, with those things on your behalf. And it's very important to have this package, not only to skip probate, but in the instance something happens to you, it gives them power to deal with your real estate, deal with your banking, and so on and so forth. And the situation John was talking about earlier, where you have issues with funding the trust. So let me just go over the basic requirements for a valid trust. Number one, the settlor, the person creating the trust, has to have the required capacity to create the trust, meaning you have to be of sound mind, you have to understand the natural objects of your bounty, which is your property, whom you plan on having inherit that property. So number one, you have to have the required capacity to create a trust. Number two, the settlor needs to indicate the intention to create a trust, which is stated in the trust document. Number three, you need to designate a trustee. Generally, it's you while you're living and for the benefit of yourself, or it can also be co-trustees. It could be more than one trustee, such as you and your wife. So you two would be the trustees while you live, and in the event something happens to you, you would designate successor trustees. Number three, you need to designate a beneficiary. And again, while you're living, you're generally the trustee and the beneficiary. But after you pass, generally that's your children. It can even be your pet. It can be a charity if you so choose. It's up to you, but you do have to designate a beneficiary. That's the fourth thing. And then the fifth thing is you have to transfer possession of the property into the name of the trust, the trustee of the trust. So for instance, if I'm forming a trust today for John, let's say we're doing a living trust, a revocable trust, after the document is signed and notarized, we would then proceed to go over to the bank and make sure the accounts that are in his individual name are then changed, with respect to the title. So it would go from John Sloan individually to John Sloan as the trustee of the Sloan family living trust, which sounds like the issue, that you had. Although you had the real property in there, the step that you needed to take was to go over there with the trust, have them retitled the accounts. Now that doesn't change your debit card. It doesn't change your checks. All your account numbers stay the same. It's just changing title from you individually to you as trustee of the trust.
But would you also recommend, though, Jesse, that you not only have that trust checking account, but you also have another individual account?
Yes, I would recommend that, especially if you're, exposed to liability, whether that be through your profession, or otherwise. It's not a bad idea to also have a small checking account in your individual name. So for instance, if the trust is cutting you a monthly check, the trust bank account would cut that monthly check and write it to you, at which point in time you could put it in your individual account. You could choose to keep it in the trust. So I would recommend having an individual account, but I would keep that individual account as small as possible to pay your foreseeable liabilities and debts and things of that nature.
Like your monthly bills, right?
But yeah, like your monthly bills and that kind of thing. And so
let me go back and ask a question with respect to the trust and the will. Because I've had a number of people that have asked me, well, if I have a trust, do I have to have a separate document, which is a will? But the trust in and of itself incorporates the will as part of the trust. Is that correct?
Well, not necessarily. So you would want a trust, and you would also want what's called a simplified will, called a pour-over will.
Okay.
If you just have a will and something happens to you and you have an estate that exceeds the $184,500 limit, you're going to probate. It's long, costly. It's really not where you want to be. So if you just have a will, you're going to end up in probate, assuming your estate is larger than the $184,500.
Got it.
So, you want to make sure you don't just have a trust. I would recommend having a pour-over will and a trust and a healthcare directive and a durable power of attorney. So I think, the proper, procedure would be to both have a living trust and a pour-over will, because the living trust is what gets you to, skip probate, assuming it's done correctly. So, you want to make sure that your trust is valid. And I went over the points or the requirements for a valid trust. Again, the required capacity, the intention to create a trust, designated trustees, designated beneficiaries. The most important part, the funding of the trust, going to your bank account, getting it put in the name of the trust, getting your real property put in the name of the trust. I would not put your car in a trust. You're likely to get exposed to liability there, whether that be a car accident or whatnot. And if you are in a car accident and it's your fault and they look up title to the car and it's titled in the name of the trust, they can generally get to those assets. Now, unless you have what's called a spendthrift provision. And we went over a little bit of that in our last meeting, which I completely recommend to have a spendthrift provision in your trust, which basically says that creditors cannot touch it until it's transferred to the beneficiary. So for the instance where we were discussing, where you have an individual account and a trust account, you have the bulk of the money in the trust account. Well, as soon as the trust account issues you individually a check for $10,000, $100, whatever it is, then the creditor can detach that. So it's very important to include what's called a spendthrift provision. If the trust instrument includes a spendthrift provision, a beneficiary cannot assign or transfer the beneficiary's future interest and a beneficiary's creditors cannot attach the assets of the trust before the assets are distributed to the beneficiary. So as long as the trustee holds the funds, the trust holds the funds, and it's not distributed to a beneficiary, then the beneficiary's creditors cannot attach those assets to the trust before they're distributed to the beneficiary. But once the trust cuts you a check for $100, that goes into your individual account. Those creditors can attach that through your
Got it.
individual account. And spendthrift protection has some limitations, including in the case of a beneficiary facing judgments for unpaid child or spousal support, restitution judgments, or to reimburse for public benefits. Now, there's also something that's interesting too with respect to Medi-Cal eligibility. The assets titled in a revocable trust, a self-settled trust, are available resources for determining the settlor, the person who created the trust,
Right.
Medicaid eligibility. However, the good news is Medi-Cal cannot seek reimbursement against assets that were in a revocable trust at the settlor's death. Meaning something happens to you, they then can't then go to your trust fund and seek reimbursement against assets that were in the revocable trust at your death. So I know a lot of people, with Medicaid, Medi-Cal, and those sort of things are interested in that kind of information. So yes, you want to create a valid living revocable trust. There's also what's called a testamentary trust, meaning the trust is set forth in the will. So the trust isn't formed today, the trust is formed when you die.
Oh, really?
Now,
Okay.
that leaves a lot on the shoulders of whom you leave behind.
Right.
That's the only problem. So that's called a testamentary trust. Your will would set forth that upon my death, a trust will be created, let's just say, for my granddaughters. Well, when you die, that means your granddaughters or your spouse or whomever is left behind, is forced getting with the lawyer, forming the trust, which, can take anywhere from a couple of months to more, depending on how ready you are to form a trust. A trust is not just formed overnight. Typically speaking, I think the trusts I do can take anywhere from, a few weeks to a few months, depending on how prepared the person is with respect to whom they want it to go to, what assets they want in the trust, et cetera, et cetera. So the problem that I see with the testamentary trust is you leave the burden on the people you leave behind. And in my opinion, it's best to have that all buttoned up and tightened up so that when you leave, it's easy on your spouse, it's easy on your children. They're already suffering, and so to make them have to go through lawyer meetings and getting things in order is just difficult for them, but it is a possibility. So you can do a living trust or
what's tough is if they don't get along.
Correct, and that happens a lot.
Wow, yeah, I'm sure it does. I don't understand the thinking behind that one, but that's okay.
Well, the thinking behind that one is, we'll leave it for someone else to do instead of
that stinks.
Kicking the can down the road.
Right.
So I definitely, all of my estates that I represent have what's called living revocable trusts, meaning you can form the trust, and tomorrow if you change your mind, you can amend it, you can restate it, you can change your beneficiaries, and so on and so forth. But definitely I would prefer a living, what's called an inter vivos trust versus a testamentary trust, which is specified in a will and puts the burden on whomever you leave behind.
Now, with respect to your real estate property, people have asked me, well, how do you put that in a trust? And the simple answer is that you record it in the name of the trust.
Correct.
And you take it to the county and get it, pay your whatever, $25 and get it recorded.
Yes, you're exactly right. So it's quite simple. Number one, you create the valid trust with all of the elements I previously discussed. You sign the trust, you have it notarized. Now, a will in California also requires 2 witnesses. So whereas a trust, you can sign it before a notary, does not require two witnesses. Your pour over will would also be signed, notarized, and witnessed by two individuals. And also your advanced healthcare directive needs to be witnessed and notarized. Your power of attorney can just be signed and notarized. So once your valid trust is created, you would then, like I said, go to the bank, switch over your account information, just retitling it from your name individually to your name as the trustee of the trust. And then you would also draw up a quitclaim deed, assuming it's in your name or you and your spouse's name. You would quitclaim your right, title, and interest over from you individually to you as trustee of the John Sloan Family Living Trust. But some people do forget to do that. Now,
Yeah.
When I handle your estate, we definitely do not forget to do that. That is one of the most important things regarding a trust is funding it. If a trust is not funded, it is invalid.
Got it. So one of the other questions that I wanted to ask, and basically it could be a statement as well. When somebody does not have a trust and they just may have a will or may not even have anything, and it ends up going to probate, talk to me a little bit about what it's going to cost that estate for not having been in a trust, because a trust, it could run anywhere from $1,000 to $2,000 depending on how sophisticated it is. But that, let's just say $1,500.
Oh, you're going to spend 10 times that. I'm
10
talking
times.
tens of thousands of dollars. And
who do you pay? Who gets paid in that situation?
Well, a couple of people get paid. Number one, the lawyer gets paid probably the most because you have to file a petition for probate. You have to run an ad in a newspaper saying, this individual has died. If you're a creditor of this person, here's the petition for probate. Or if you're a beneficiary of this person, here's the petition to probate. It gives them all an opportunity to come in and take whatever money they believe is owed, or at least assert what they believe is owed. And like I said, you have numerous court hearings. Eventually, before you file your petition to probate, you better have the original will, because number one, the court's going to make you go down to the courthouse and lodge your original will, not a copy. They will not accept a copy. If it is not a copy, you're just out of luck. And so number one, you're going to have to take that will down to the courthouse, and you're going to have to lodge it so that they can see that it's an original will. And then you'll file your petition to probate. You'll put your notice in the newspaper to creditors and beneficiaries alike. You'll have to send notices to all of your beneficiaries, all of your children, your grandchildren, your great-grandchildren.
Wow.
Just in postage and legwork alone, you're looking at $15,000, probably in that neighborhood, and you're also looking at a few years spent. I'm working on a probate right now, and how I wish I had known them many months prior to my introduction to them. I could have saved them a lot of money and a lot of hassle. Like you said, it's better to spend a little money up front than a lot on the back end. And nothing is guaranteed in probate. They could say, well, the will wasn't done right. A lot of people like to draft their own wills for whatever reason.
So who gets
my mind?
But who gets the asset then?
Oh, well, whoever the will specifies gets the asset.
Okay, but if there is no will,
it still can go through what's called intestate succession, meaning if you leave a spouse behind, it would go to your spouse. If you leave your children behind, it goes to your children. But like you said, if nobody gets along, everybody's fighting and saying, oh, he wanted it to go to me. No, he wanted it to go to me. Everybody's lawyered up. But to answer your question, a lot of money goes to the lawyers. A lot of money goes to the court filing fees. In the worst case scenario, it can escheat to the state. Meaning your money can go to the estate.
Like they need it, right?
Right. Yeah. No. Exactly. But that's the pitfall. So it's just a lot of time and money spent. It's better to spend let's say a few $1,000s up front, then tens of thousands on the back end, with no guaranteed result.
Well, that's a lot of information. The last question that I have is when you had talked about the estates that are less than $185,000 and it goes into probate, you're obviously not looking at the same kind of costs as you are
Correct.
the other way, correct?
Yeah, it's called a small probate. It's a lot quicker. It's a lot cheaper, but you're still looking at paying court filing fees, and so on and so forth. But yes, if you have less than $185,000, that includes real estate, cash, money market accounts,
Mm.
whatever, paintings, pianos, you name it. So if your estate is less than $185,000, you can go through a more simplified version of probate. And probate's not easy on the people you leave behind either, because not only are they mourning you, but then they're dealing with all these people coming out of the woodwork saying, I want this, I want that. He owes this creditor this, he owes this creditor that. And then, finally, you get to a situation in probate where you put forth an inventory and appraisal, and it says he's got this cash, this account, this real property. And assuming it goes over that $185,000 mark, then you're going through the full, more complicated probate process.
Jesse, you've been a plethora of information, and I appreciate you taking the time.
Sure.
One of the things that we're going to be doing with Jesse as part of our free commission giveaway is that he is going to supply somebody with a free trust sometime down the road at one of the monthly giveaways that we have. Jesse, how can someone get a hold of you? What's the best way?
Well, you can reach my cell phone number, which you have, or I can provide here.
Sure, go ahead and do that.
It's area code 818-913-0001. So again, that's 818-913-0001. And I can also be reached by email, which is pratherlaw.esq@gmail.com. I really got into the legal business to help people, believe it or not. And, that's what I like to do. And I'm always open for free consultations to maybe answer a couple of questions you may have.
Great.
And if I can help you, I would be more than happy to help. If I can't, I'm sure I know someone who can. So.
Well, just having this conversation certainly made me full understand that you've got a pretty good depth of the knowledge of probate and trusts, and I appreciate that. And again, anytime that I'm working with a home owner, I am pushing them really hard if they don't have a trust to get it done, because I know that having worked with someone who had passed away and couldn't find their brothers and sisters, we finally did. It ended up costing this estate close to $45,000 in order to get everything taken care of. And those are funds that certainly could have gone to a beneficiary if it had been done properly. So, spending $1,500 or so to have a trust done is certainly well worth it. And
Sure.
You also have the opportunity to give you a call after the trust is done down the road to, get clarification on things as well.
Yeah, and it makes it just easy on who you leave behind. It's literally like a turnkey operation. God forbid something happens to you, it makes it so easy on those you leave behind.
Yep.
If you have to go through the probate process, it is not easy, it is not cheap, it is very time consuming. Nothing is guaranteed. Whereas with a valid trust, it's like turning over the keys. They can walk into the bank, they can get the accounts, they can distribute it in accordance with your wishes. They can deal with your real estate as the successor trustee to you. You're just doing them a real big favor doing that. And so that's the bottom line. And
all right, folks, we are talking with Jesse Prather. He is an attorney at law and he does trusts and can certainly answer any of your questions. So Well, your phone number is up as well as your email here. So give Jesse a call if you have any questions. Jesse, I want to thank you again for your time and look forward to whoever's going to win this trust.
Yeah, you're
from
going to
your
be
company.
a lucky winner.
Great.
Someone out there is going to be a lucky winner. And thank you, John. Appreciate your time as always.
You're
And
welcome.
anyone, please feel free to give me a call. That's just how I operate. I like to help people. You can talk to all of my clients. They'll tell you the same thing. I'm willing to spend the time and the energy to fix whatever issue or problem you may have, or to avoid problems such as.
There you go. All right. Thanks again, Jesse. Have yourself a great day.
Yeah, you too. Thank you, John. Appreciate it.
You bet.